Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to continue our series on the 8 goals of a good estate plan. Previously, we've discussed 4 goals that apply to almost everybody. And now we're going to move into talking about 4 goals that apply only in special circumstances. So if you have one of these special circumstances, this is something that a good estate planning attorney can dig in and resolve for you. The goal we're going to talk about today is estate tax avoidance. You should worry about estate tax avoidance if you have more than $4 million in assets, including your life insurance death benefit. That counts as an asset for you for estate tax purposes. Or if you believe that before you pass away, you might accrue $4 million in assets. The reason we talk about that $4 million mark is because on the state level, the state of Illinois has a $4 million estate tax exemption. Your estate tax exemption is the amount of your estate that is not taxable. So Illinois can only apply estate tax to estates that are over and above $4 million, and they only apply it to the amounts that are over and above $4 million. The federal exemption is $5.45 million actually in 2016. So federally, estates over $5.45 million are taxable. So what we try to do is make sure that if you have an estate that's valued over that $4 million mark, that's the lower mark for Illinois, anything over that $4 million mark isn't going to be automatically exempt. We try to take things out of your estate for tax purposes and make sure that as much of your estate as possible passes to your loved ones and not to the government. The estate tax can be pretty onerous. If you have a taxable estate, the estate tax federally can be anywhere between 18% of your taxable estate to 40%. So almost half of your taxable estate can go to estate tax if you don't do proper planning. We have several tools we use for estate tax planning. The first line of defense is something we call an A/B trust strategy. And what this does is it allows spouses to take advantage of each other's estate tax exemption. And so what we do for a couple that's not worried about estate taxes, we'll do a joint trust for the couple. They'll have one trust. It'll keep them out of probate, which you can read or listen to in our previous article about probate avoidance. But we'll do one trust for a married couple that's not worried about estate tax. But if you have about $4 million, including your life insurance death benefit, what we'll do is we'll do a separate trust for each member of the couple. And by doing that, without getting to the arcane details, we allow each member of the couple to take advantage of each other's estate tax exemption, effectively raising the estate tax exemption for the couple from $4 million as an individual to $8 million as a couple. So as long as now you've got less than $8 million of assets and you do this two-trust, A/B trust strategy, you don't have to worry about estate tax because you can take advantage of each other's exemptions. So when the first person passes away, if they have more assets in their name than their individual exemption, the $4 million Illinois exemption, so say they have $5 million in assets, they can borrow in advance from their spouse's exemption and apply $1 million of their spouse's exemption to the amount that was over and above their own exemption. And similarly, if they have less than the $4 million in their estate when they pass away, they can apply whatever exemption they have to their estate. So if they have $3 million in their estate, they've got a $4 million exemption. They can apply $3 million of the exemption to their taxable estate and then give the remaining $1 million to their spouse, so that everything that's already been, the exemption's already been applied to when the first spouse passes away, passes free and clear to the other spouse, exempt from estate tax, and it'll pass to their children exempt from estate tax, and now the remaining spouse has $5 million for assets that he or she accrues in the future, rather than their own individual $4 million exemption. So that's a lot of jargon there. So basically the bottom line is by using 2 trusts instead of 1, we can allow couples to raise their estate tax exemption in Illinois from $4 million to $8 million. And that takes a lot of people out of estate tax world. That for most people, that's all we need to do for estate tax planning. Federally, that's automatic. Federally, we don't need trust to do that. The federal estate tax is already portable, so couples can already take advantage of each other's exemptions on the federal level, but they can't on the state level. So that's why it's important to avoid state estate tax, to make sure that you have a separate trust for each member of the couple. in order to take advantage of each other's exemptions. So that's the easiest and first step that we do for estate tax planning. You don't really have to give anything up to do that. The second step is irrevocable life insurance trust. So if you still have a taxable estate after we've done your AB trust, you've got more than $8 million in assets, and some of those assets are a life insurance death benefit, say you've got $1 million or $2 million in life insurance death benefit, we can take that death benefit out of your estate for tax purposes by doing an irrevocable life insurance trust. And basically what that does is we change the owner of the policy, the life insurance policy, to this irrevocable trust. And you can continue to fund it over the course of your lifetime, but you can't change who the beneficiaries are. So if you decide you don't want the beneficiaries to inherit that life insurance policy when you pass away, you can't change that anymore. You can stop funding the policy, but you can't change the beneficiaries. Now, for people who want their spouse and then their kids to be beneficiaries, we don't anticipate that's necessarily going to change. So we don't really worry about doing an irrevocable life insurance trust. We can do that without the worry that they're later going to want to change their mind about that. So it's a really easy way to take the life insurance death benefit out of your taxable estate for estate tax purposes. If after we've done both an AB trust and an irrevocable life insurance trust for a couple or an individual, they still have a taxable estate, then we get into more advanced strategies, and the next step would be something called GRITs, GRATs, and GROOTs. Those are acronyms for Grantor Retained Income Trust, Grantor Retained Annuity Trust, and Grantor Retained Unit Trust. And what these are good for is transferring business assets or real estate assets, or really any type of asset, but it's most commonly used for business and real estate, into an irrevocable trust, and the value of the asset at the time you transfer it is what's counted as part of your estate for estate tax purposes. But value that accumulates over time from the date that you transfer it into this trust is not part of your taxable estate. So if you have a piece of real estate worth $1 million and you put it into a trust, and then over the course of the rest of your life, it raises in value to $5 million, only that $1 million value is part of your taxable estate. The accumulated value of $4 million is not going to be part of your estate. Now, the downside is that with these trusts, you can't sell the property during your lifetime without the sign-off of other beneficiaries. So what you do is you're going to be a beneficiary of some income from the trust during your lifetime, but you've basically said, I now agree irrevocably that my kids or my other loved ones are going to inherit this property, and you can't change that without their sign-off. So the way it works is you're going to be paid over the course of several years, according to your trust agreement, either a fixed amount, an annuity, any income earned by the trust, that's a grantor retained income trust, or a percentage of the value of the trust every year. That's what happens in a unit trust. You get paid that every year until the trust terminates. When the trust terminates and you've got to put a set amount of years, then whatever is left in value in the trust gets transferred to the beneficiaries, your loved ones. So that's a good way. It's kind of complicated and it's something to talk about in depth with your attorney, but it's a good way to take assets that you think are going to accumulate in value, like a business, like real estate, out of your estate, and only have the value of the asset at the time that you transfer them be applied to your estate as far as estate tax. So that's a really good strategy for someone who's around the $8 million limit, but is afraid that their business or their real estate over the course of time is going to push them over that limit. And again, the downside is that you lose some control over that asset. You still get to enjoy the income from it, or whatever set amount that you're going to get paid every year from it, but you no longer have the ability to sell it without the sign-off of your beneficiaries. Once we get past GRITs, GRATs, and GROOTs, another big strategy is a gifting strategy. So that's actually transferring assets from you to your children or to your loved ones during your lifetime. And there's $14,000 per person that you can gift every year without any sort of tax penalty, without gift tax kicking in. So the downside is you're actually giving away your assets during your lifetime, but if you have an estate and you're trying to transfer it to your loved ones without it going to the government, the sooner you start this gifting strategy, the sooner you can reduce your taxable estate and get your assets to your loved ones without estate tax. Finally, we have generation skipping trusts. So this is for people who are worried about not their own estate tax. They can cover everything in their own estate as far as estate tax purposes, but when they transfer it to their children, they don't want it to be taxed on their children's level. They want to keep things out of their children's taxable estate. And the really simple way to do this is a generation-skipping trust, where we create a trust that's going to go to the grandchildren or great-grandchildren, skip the generation. So you give everything up to above your children's estate tax limits to your children, and up to your children's estate tax limits, and then everything above that would go into the generation-skipping trust and transfer to the next generation without being subject to your children's estate tax. Now, that's a lot of stuff I've thrown at you. Estate tax planning is probably the most complex aspect of estate planning. So it's important to work with an attorney that's pretty good at it and is willing to come up with a customized strategy for you. When I work with clients on this, I never have a pre-canned estate plan idea. I want to find out what their assets look like, what their goals are, what they're willing to give up in order to accomplish their estate tax goals. So thanks so much for listening. Check out more videos, articles, podcasts at learn-about-law.com. And if you really enjoy what we're doing here, you can download us and leave us reviews on iTunes, and that'll help us be found by more people. Thanks so much.